So, yeah. Good afternoon, everyone. I am Manya Khanna, Operations and Corporate Relation Associate. Welcome you all on behalf of Karuna Mediation and Arbitration Institute and our founder, Mr. Sahil Kapoor. So, being a family dispute resolution practitioner and a mediation enthusiast, he founded a Karuna Mediation and Arbitration Institute as a vision to spread awareness of mediation for resolving disputes with compassion and empathy. Karuna Mediation also imparts IMI and CMC recognized mediation training in coordination with the essential mediation solutions with United Kingdom. For trainings, you may check our websites and our social media handles also. So in progress and awareness towards our vision, we organize these webinars to spread awareness about mediation for students and professionals who all will be the future building blocks for this sector. So for today's webinar, we will be having a mediation as a profession series 3 to impart and share knowledge about today's topic. Our guest speaker, sir, advocate, mediator, and an arbitrator too, Mr. Sameer Shah, sir, will throw light to all the facts related to mediation as a profession and how one can be a successful mediator in today's era. Sir has a 25 years of active legal practice in various law, and he is a senior partner of Trust Legal and also founder of SU Shah and Associates, which is a full-time service law firm in India, which is undertaking both litigation and transitional assignments for both Indian and foreign corporate clients. And since 2000, Sir has been emerged in mediation and arbitration also. He has served as a counsel, arbitrator, mediator, and advisor to the wide range of disputes. He's a director he's a director also of a Chartered Institute of Arbitrators in London in an Indian branch, a chairman of International Dispute Resolution and Risk Management Institute, Hong Kong, of an Indian branch, and an adjunct senior lecturer of an Academy of International Dispute Resolution and a professional negotiation, Hong Kong. Sir has been empaneled as a mediator with various mainland Hong Kong Joint Mediation Center and also as the Hong Kong and the Mediation Center, Dubai. Is also acting as a coach and the tutor for the various competition teams which are having a competition in mediation, arbitration, and negotiation. He is also regularly conducting training courses as a tutor for Chartered Accountants of Arbitration India at Mumbai, Delhi, Chennai, for training professionals as an arbitrators, and also conducting various awareness and training programs, especially modeled for the law students in various law schools in India. Sir has also been a committee member at High Asia International Arbitration Center and member of steering committee at Campaign for Greener Arbitration, and also co-founder of India chapter at Energy Related Arbitration Practitioners, ENRP. So it's a pleasure, sir, to have you with us, and also a pleasure to have such a wonderful audience. And I request you everyone, before proceeding further, to please switch on their cameras and please put your mics on mute. If you have any questions in between of the session or in the end of the session, so please put your questions in the chat box, or you may raise your hands and you may ask that particularly. So, sir, as in our previous webinars on this topic of series, our speaker, Mr. A.J. Jawad and Ms. Iram Majid, have shared their viewpoints on mediation as a profession in India. So today we will be discussing your viewpoints on the particular topic.
Thank you, Manya, for that brief introduction. But just to correct, I think it's not an updated profile which you may have. Couple of things. I have a 28 years of active legal practice now. It's not 25. So far as my Hong Kong association concerned, it used to be there earlier, very active, but because of the current political situation, I have stopped acting for that Hong Kong part of it. So just to clarify on those parts, yeah. And that's okay. That's fine. Now, before we start the interactive session, let me just share with you about the significance of today's date, today's day, um, in relation to mediation. So, does or is anybody aware of what's so special about today's day? Anyone? All right. So today is the day which is celebrated as the World Suicide Prevention Day. Okay. And I'll come to why I'm sharing this and what is its relation with mediation. And yesterday, the day was known as Are You OK Day, especially in Australia and New Zealand. So now try to understand the significance of these 2 days, and especially when we are talking of suicide. One of the major reasons of suicide, in my experience, is lack of communication. Yeah, either mainly lack of communication, or it may be misunderstanding. So basically, it relates something relating to communication, either more communication, misunderstanding of the communication, or no communication at all. And that's where it is related to mediation, because what happens in mediation is structured negotiation. And when we are saying about negotiation, it's basically communication. When I say you, means both the parties as well as the mediator. They are communicating, which is known as a conversation, yeah, with each other. And through that conversation, the mediator tried to facilitate the parties to walk towards a path of settlement or resolution. That is what happens. I think I need not tell you what mediation is all about. You, as Manyas just said, that you already have 2 series. So I'm sure the other two speakers would have mentioned what is mediation, and of course you would also know what mediation is. But this is what, in nutshell, is mediation. It's basically structured negotiation facilitated by a mediator. All right. So this is what I wanted to share with you about today's date and how it is related to mediation, and we'll discuss this about the concept of effective communication and conversation, dialogues. These are the words which are used in mediation. We don't use arguments, we don't use submissions, we don't use representations. We use the words dialogue, conversations, communications. Yeah. To make it totally different from the general or usual model of dispute resolution. That's the whole purpose. And it actually, this is what actually happens in mediation, that through dialogues and conversation and a structured communication, the parties try to resolve their dispute through the help of the mediator. That is what mediation is all about. Yes, Manya, over to you.
So, as you said, that mediator helps the parties to bring out the solutions in their disputes.
Yeah.
So, what you say that how mediation be useful in resolving disputes as a win-win outcome for both the parties?
Well, I think your question actually has part of the answer, because it says win-win solution. And that's exactly what mediation helps party to do it. It tries to arrive at a fair balance between two parties and work out a situation where both the parties go out happy. They depart happily, not with any grudges, not with any other negative feelings. So that is why we say that mediation is a process where the outcome is win-win for both the parties. However, there is a misconception amongst general public, and even to even in lawyers, in clients, in corporates, that when we talk of mediation, we are talking of compromise. It's not compromise. Try to understand that. What is a compromise? A compromise is that you forego something which, according to you, you have a right over. Correct? But you waive that off, you waive that right, you forego your interest for something to gain something. That is what we normally understand as what is compromise. If you are foregoing something. Now, you have to understand that, but compromise has been understood in a negative way, and it is being used in a negative way. As I just mentioned, where the meaning of compromise is that you are waiving off, you are foregoing something of your interest or your right. That's a negative understanding. But it has a positive understanding as well, the positive meaning as well. And that is what I just mentioned, is that you are foregoing something to gain something. That is also part of a compromise. Otherwise, why you should be foregoing? Why? Think from a party perspective. Why a party would be foregoing something? Because that party feels that by foregoing, by waiving of some right or interest, he or she would be gaining something more than that. Yeah? Maybe not more, but at least something would be gained. And what is that something? That depends upon case to case. But ultimately, one such something is maybe a resolution to the dispute. Yeah. So if we look from this perspective, then it is win-win for both the parties, because each of the parties would be thinking like this. They will come with such a mindset, or even suppose they don't have that mindset initially, but when they go into the process of mediation with the help of the mediator, and fortunately if they have trained counsels, mediation counsels, then through them they would try to understand the whole process, and they would try to appreciate this part of positive compromising. I would say I would qualify the word compromise with a word positive, because in general parlance we use compromise in negative way. So when we look from a positive aspect, then we can understand that ultimately it would lead to a win-win situation where both the parties are happy. And this is the only process in ADR where the parties go happily after resolution. Take example of court. Definitely there would be a loser and a winner. In arbitration, again the same thing. But it is only in mediation where both the parties will go out happy. And that is why we say it's a win-win situation. And why so? The reason being, here the mediator is not imposing any solution to the party. The mediator is not suggesting any solution. The mediator is not supposed to even suggest a solution to the parties. But through discussion, asking questions, which is an art, yeah. For that matter, mediation itself is an art. I would say there is no science. It's not a science. It's an art, which is not cup of tea of everyone. With all due respect, I mean, it's a fact. So through that process of discussion, through that process of asking effective questions, the mediator leads the parties to an effective, mutually agreeable solution. And when we say it's mutually agreeable, is of course a win-win situation, because both the parties are gaining at this. They may have lost something, but at the same time they are also gaining. So that's why we say it's a win-win situation. I hope that clears the question.
Yes, sure. Yes, sir.
If someone has any doubt, they can we can discuss it right away. No issues on that. I'm happy to answer that.
Yeah, anyone, if you have any doubt related to particular
Or
question.
maybe you want to share something, I would be happy to listen to you. All right. Give them some more time to think over. No problem. We can go ahead. Yes.
Yeah, sure, sir. So, sir, as being you are now the very senior mediator and upcoming from 2000 the year 2000. So, what your thoughts on like that? Ki, whether mediation profession can be the standing alone profession in India?
See, this I cannot give you a straight answer to this. There's no straight answer because it is a very subjective matter. And when I'm saying subjective, because uh, it's up to a person how he or she wants to progress in the career. Of course, if you look from international perspective, you will find so many people who are, who are acting or who have adopted this as a standalone career, as a mediator. Yeah. And so again, as I said, it's a very subjective matter. So it all depends upon a person, how much interested that person is for mediation. And here, let me just share something with the participants. And I mean, it's a truth as such. In my experience, I mean, you may not agree. I'm not saying you should also agree, but what I feel is that if you have a personality or a mentality where you don't want to go into conflict, you don't like conflict, or you go away from conflict, then you are not fit for mediation. The reason being, as a mediator, there are two parties who are already in conflict, and they are approaching you with a expectation, with a trust that you, as a mediator, would be helping them out to resolve their conflict. Now, if you, as a mediator, are a person with a personality who doesn't like conflict, who don't want to engage into all this kind of issues, then you are not fit for mediation. Mediation or a mediator is a person who can sit along with conflicting situations with all peace of mind, with such calmness, yeah, and humbleness to help the parties. So if you have a nature of, in India, you would have seen, if there, let's say, there's some accident happening on the road, then you will see maximum people gathering around that particular spot as spectators. Hardly anyone, or very few, would simply go to that particular person to help. So if you are of that person who are spectators, then you cannot be a good mediator. It's like this. So it's very subjective. You need to have that mentality. You need to have that mindset to help others, then only you could be a good mediator. Furthermore, you need, apart from simply helping, you also need to have that mindset or the feeling of empathy. I think you would have heard this word so many times. And it is very important. Does anyone can tell me difference between sympathy and empathy? General English understanding, I'm saying. There is nothing specific to mediation, but I'm just
So,
asking, do you know the difference between sympathy and empathy?
so
Yes, Prajwal.
sympathy is something that something has happened to a person and you feel for the person, that you feel sorry for something. But empathizing means that you step into the shoes of that particular person and you feel from his side whatever he's feeling about that particular situation and what would be your thinking in that particular situation. This is my understanding of
No,
the term
just
empathy.
you are no, Prajwal, you're right. You're right. But only let me just correct you on the last part.
Sir,
Not thinking of what you would be thinking, thinking from what that person would be thinking. Because you have stepped into that person's shoes already. So you have to think from that person's perspective, not from your perspective. Then only you would be able to empathize with that person. Yeah. And then only you would be able to help that person. Then only you will be able to analyze and understand what is wrong, what is the issue, where that conflict, where the root of that conflict is. Yeah. That's important for you as a mediator. So coming back to the question, as I said, it's subjective, but definitely there is a huge scope and opportunity, especially in our country now, to pursue this as a standalone career. Now, let me just share with you some, opportunities for that, and why I'm saying there's opportunity. You see, you all would be aware probably that by end of this year or maybe next year, India would come into league of very few countries across the world where we'll have our own standalone mediation law, which will definitely open so many doors and opportunities for engaging yourself as mediator in our country. We know how our courts are backlogged with the cases, and mediation is the only solution. But the problem is that we don't have those trained and qualified mediators. Now, if you ask any lawyer, or for that matter, any person, he or she will, yeah, I know. And in a way, that person is right, because we are engaging in mediation in our day-to-day life every day, be it with any relation, family, friends, even foes for that matter. But those are very informal, ways of diffusing the conflict, I would say. When you come in mediation, you need to have a proper laid down process, a proper laid down structure. Of course, within that process, mediator can definitely employ different tools, different methods, different techniques, different strategies, depending upon how the things are flowing, how the conversation is flowing in that mediation room. But it still need a professional outlook. So then coming back again to the opportunities, you see our Commercial Courts Act in 2018, a very important amendment came in that. Now it has become a mandate that no commercial suit can be filed in the court before it is being mediated for 3 months, which of course can be extended for 2 more months by the parties. Yeah, which is a very important and good step for promoting mediation. So again in the recent amendment in Consumer Protection Act, mediation had been part of the dispute resolution process. So there are now legislation coming up. The government is supporting mediation. the judiciary is supporting mediation. Therefore, there is a big opportunity for anyone who want to, take up this mediation as standalone career. Definitely. However, let me just also give the flip side of it. And that flip side is, of course, the commercial aspect. Unfortunately, in our country, especially I'm talking from the client's perspective, mediation is not still viewed as an important tool of dispute resolution. And therefore, to that extent, of course, the commercial returns, when I'm talking commercial, the fees basically, are very low. However, if you are still contented with it, in the sense that if you are a person who feels satisfied, who feel contented, who feel happy to help others, no matter what you get in return, more or less, definitely this is the profession as a career you can choose. No problem, no doubt about it. And I'm sure going further, of course, when the law come into place and these amendments which are very recent, they are actually being implemented with all the force. Definitely will need so many mediators, and there would be a good many opportunities openings for this. Yes, Prajwal.
Sir, I have two questions. That first is related to what you have said just now about the mandate of pre-litigation mediation and commercial matters. So, sir, what is your view on because in India, majority of disputes are directly or indirectly related to property matters. So, what is your view on mandating pre-litigation mediation in property matters, specifically talking about land disputes and other? And
you see, sorry, yes, go ahead.
And so my second question is, what are your views on online dispute resolution and how it has affected the traditional method of mediation of physical sitting? And
okay, coming to your first question, I can answer that is just in one sentence, and that is, whatever dispute which can be litigated must be mediated. I hope that should answer your first question. But just to explain that part, whether it's property related or I'm saying it is related to intellectual property rights, whatever, family dispute, partnership disputes, whatever is there, mediation can definitely play a big role, an effective role for settling such disputes, resolving such dispute, I would say. And as I said, this particular amendment in the Commercial Code Act definitely is a very important and good step taken by the government, to promote mediation and to, of course, because you see what is happening, if you look at from the court's perspective and the statistics which are there, majority of the cases which are pending in the court are, based on simple, as I said, and that takes back to my earlier discussion of lack of the part of communication. Either there is lack of communication or there's misunderstanding. Now, this part, the court will not look into it because court is bound by law. Yeah. And very, very correctly, ultimately, because court cannot go beyond law. The court has to function within the boundary of law. But in mediation, it's so flexible that you can still, I'm not saying you can forego or you can waive off the legal positions, the law as such, but you can still have that flexibility of working on different options in mediation for that particular issue. And this is where the communication would improve, because the parties are made to sit together face to face in that room with that neutral person, the mediator. And of that where the whole process of cutting the ice would take place. You take example of family matters. in my experience, majority of these matters are because of ego. Even commercial issues, commercial matters, partnership disputes are because of ego, or that kind, or maybe that revenge mentality. Yeah. Now all this can be diffused in mediation very well, but it cannot work in court because court will not look into it. Court will say, okay, who's right, who's wrong. But here we are in mediation, we are not saying who's right, who's wrong. We are simply saying where you are, who you are, what are the problems. Right and wrong comes later. What you would have learned is about positions and interests. That's very important. That is where the whole mediation revolves around. So I hope that answers your first question. Now, coming to the second question of online dispute resolution. In fact, I was just before this webinar, I was discussing with someone in Italy on mediation only, and as a matter of coincidence, we were also discussing about ODR, and I told the guest on that meeting that, in my view, ODR is not that cannot be effective in mediation. And there is a reason behind it. Because in mediation, we are talking or we are discussing about emotions. We're discussing about human relations. Now today, it's very difficult to gather up and to understand someone sitting across, facing you on a screen, and understanding that what's going behind that person's mind. I mean, there can be a counter that you cannot even do it if even that person is sitting in front of you, but still, with the body language, the facial expression, there's so many ways to understand the other person's emotions, the thinking. Though of course it need that experience, you need that training and understanding, but it is more effective if you are in person rather than online. So to that extent, I would say ODR will not be that effective in mediation as compared to arbitration. Yeah, Jagrati?
Yes, sir. Sorry, I was just typing it in the chat. So, my question was around the mediation bill. So, considering that there is a possibility that we will have statutory recognition to mediation soon, what are your thoughts around government being possible, outside, maybe an outside the ambit of the mediation bill? If in a non-commercial dispute, one of the parties is a government, and unless there is basically a state or a central specifically mentions whether that needs to be included or not, what I understand from whatever I'd read in a mediation bill, I had a cursory glance, is where there is a possibility that government will be outside the scope of the mediation bill. So what is your thought process around this? Because one of the things, as you rightly stated, that whatever can be litigated should be mediated. And if we see the statistics in terms of litigation, 80% of litigators is government. So then what do you feel will be the success ratio of this?
Well, I think I definitely have very positive thoughts about it, in the sense that if you see the litigation or the reason behind the litigation which is happening, where the government is the party, majority of such litigations are there. As I said, again, it goes back to that issue of communication. Either there is no communication at all, the government is sitting tight on something, not replying, or what the government replies is misinterpreted by the government itself or by the other side, and then there is a dispute. So therefore, in this kind of situation, ultimately, what the court would do as I said, the court is bound by law. The court will look from the law side that, okay, government is right or government is wrong, and matter ends. But does it actually give the justice? Does it actually deliver justice? We have seen in many cases, you would have read in newspapers and the periodicals or articles, that ultimately, and you feel reading that this is wrong. Why? I mean, the court is wrong. You feel that way. Yeah, many times you would have felt like that. This cannot be right. But as I said again, court is bound by law, and therefore again, I usually say when I'm giving this kind of talk or lecture, I usually end that, especially on mediation. I usually end saying that in court you will get law, but it is only in mediation that you will get justice. And therefore, coming back to your question that about the bill and all, definitely I'm saying that government, it will be definitely effective even in case of government, because if you take issues of let's say contracts which are given by the government, the tenders and all, they are basically commercial disputes, and at the end of it, let me just tell you, the government also knows that they are wrong. In majority of the cases, they know that they are wrong. It is only because the particular officer does not want to get entangled into issue of uncalled for investigation from the vigilance department, or being said to be corrupted, or influencing some party. Therefore, they themselves ask the parties to go into arbitration, and then they will not challenge it. They will say, okay, the arbiter has given this award and we have paid it off. They know that they anyway knew from the very beginning. They knew that they have to pay this, but just they give this the whole process, try to give the authenticity of an arbitration or a litigation to come out of this issue of unnecessary investigation later on. This majority of government cases are because of this. Yes, there would be few pertinent issues, I would say, but then they have to be decided by the court. Their mediation, I don't think mediation can be used as such, because those would be the issues relating to public at large. Because when we are talking of mediation here, we are talking of two parties, inter se. But there would be issues with the government where the public at large would be affected. There, I don't think mediation can play any role as such. I think there was someone else also raised the hand.
It's I think so. So they have written down their questions in the chat box itself.
But is it related to this thing, or we can take it later?
Actually, it's related to mediation and mediator itself, accreditation
Right.
to the mediator. Yeah.
No problem. We can take it up. No issues. No problem.
Now itself we can have it.
Yeah.
Yeah. Okay, Mr. Sumesh, you may have your question, please. Mr. Sumesh. Mr. Sumesh, you may speak out your questions and unmute yourself, please.
Yes. So I want to know what is the affect your session as a mediator, and is it very important, and like what you mentioned.
Mr. Sumesh,
So
we cannot hear you properly. Your audio is not coming out clearly.
Yeah, I can say the questions on behalf of Mr. Sumesh itself.
Yes.
Yeah, Mr. Sumesh asks that, does accreditation affect your chances of establishing as a mediator? If yes, what would be you recommend?
Well, you see, it doesn't have a straight answer. But if you're if you're looking from the proposed Mediation Act, then of course accreditation will play a big role if you want to act or if you want yourself to be appointed as mediator after the act comes into play. But as of now, there is no such requirement of accreditation. According to me, what is important is the experience of a person rather than accreditation. And of course, accreditation and experience are as such related, but still, a person can be very experienced but may not be accredited. There's no problem. It doesn't belittle that person's experience or expertise as such. So, as of now, what matters is your own knowledge and experience about the subject matter of dispute. That is more important. But as I said, once the act comes into play, definitely accreditation will be a mandatory part to be appointed as mediator. And what was the second part? What was the second part of the question? I'm sorry.
The second, it's just that is there any chances establishing as a mediator? If yes, then what would you recommend? Effect of accreditation.
Okay. So yes. So as I said, that of course the act would come into play probably by end of this year or maybe next year, definitely. So it is always definitely suggested, advisable to have a proper certified training and accreditation. But the issue would be that, let's say, just take example of Karuna mediation. They give you accreditation from CMC and IMI. Suppose today you have taken the training from them and you get that accreditation from CMC and IMI. But the problem is whether the Indian government recognize those certification or not. That is important. So as of now, your even today, let's say if you're taking this course, the training course, and you're getting the accreditation from CMC or IMI, it's good for you, I would say, from the international perspective, because internationally these are recognized, accreditation institutions, bodies for that matter. But how far that would be acceptable in India, we can't say. As of now, there is no answer to that. So you have to take a decision accordingly. But going further, if you want to practice in India, then after the act comes into play, accreditation will be a must. Now, from whom you are getting the accreditation will obviously follow once the act comes into play. We'll know to whom the government or the MCI, which is the Mediation Council of India, would be accepting as the accreditation service providers. So I hope that answers your question, Mr. Sumesh.
Yeah, he has some connectivity issues. He mentioned in the chat.
Yes, that's okay. We can, that's fine.
Yeah. So we can take up one more question. So my next question is, being a mediator, could you please enlarge with more insights how one mediator can take up or build up or his career in mediation itself?
But before I take up, I think there's one hand which is raised by Mr. Abbas from Doha.
Yes.
Hi.
Yes, Mr. Abbas.
Hello. How are you? Fine?
Fine. Tell me.
Yeah. My question is related to the mediation, whether the person from legal background only needs to be practice the mediation or any other background is okay.
Well, listen, a mediator need not be a lawyer or a judge for that matter. There's no requirement, there's no necessity, I would say. In fact,
Okay.
it is always better that a person who acts as a mediator, and as I just was answering the last question, must be a person who has the expertise or knowledge of that subject matter dispute. Now, he or she can be a chartered accountant, company secretary, or a doctor, or whosoever, maybe a teacher for that matter, engineer, anyone can be there. But what is important is the expertise and the knowledge of that particular person. So it is not necessary that only lawyers or the judges should be mediators. You see, what happens is, yes, the concept of this or the culture of this, majority of the, if you look around, you will see that majority of the mediators are either lawyers or judges. The reason being that at the end of it, let's say when the discussions or the mediation process is going on, there might be issues related to law coming into play. Now, a person who's not a lawyer or judge may not have that knowledge or information or experience or expertise about law. And therefore, he or she in such a scenario may mislead the parties to a totally wrong resolution, which is against law. And therefore, it is said that, and therefore we see that there are more lawyers and judges who are appointed as mediators. But as I said, there's no such necessity. Even a person like a CA or a company secretary or any other common man can also have the knowledge or get the knowledge of law. At the most, that person, if sitting as a mediator, can take help of a lawyer or judge as an expert to help him or her with the law part. There is nothing stopping such things. So it need not be a lawyer or judge sitting as mediator.
No. For example, in construction disputes, in international construction disputes, there is an alternate dispute resolution process where one of the dispute resolution is mediation. Then it comes the arbitration. So, in terms of mediation in construction projects, so the technical background person knows the subject well. So normally what happens is when it is getting appointed by international consultants, so they take the job, then under them they will take a legal company under them for the legal advice from legal point of view if any concerns are addressed. So being a background from the construction, so if ADR is mediation in most of the projects, international projects, after going to arbitration. So that's why I was asking. But in India, I don't know. In India, in construction disputes, whether mediation is going to be mandatory or not, I don't know.
Well, as of now, no, I don't see that to be a mandate. But of course, all these cases goes into arbitration majorly, and where in India we find the retired judges or senior lawyers who are expert into construction disputes are sitting as arbitrators. Now, to some extent, the trend has started to appoint engineers or the subject matter expert in such construction dispute, but still the major part, the major system is like this, that depending upon, of course, the claim amount and who the parties are, retired Supreme Court or High Court judges would be appointed as arbitrators, and then they would seek help of engineer as an expert witness to help them out with the technical aspect. So it's a reverse situation in India as such.
Yeah. Because my question was in arbitration also, if the dispute is related to the technical subject, then legal will be the secondary part. So if it is related,
Not exactly. You see, that is the major difference between arbitration and mediation. Because in arbitration, the arbitrator or the tribunal has to finally adjudicate and decide the dispute. And when we are talking of final adjudication, it definitely involves law. But in mediation, that will not be the case, because mediation can be unsuccessful as well. And many times it becomes unsuccessful. So there is no question of law coming to play from the very beginning. Whereas in arbitration, there is always a law from the very beginning. You have the governing law, you have the the procedural law taking into place. So anyway, coming back to mediation and to your question, the answer is that no, there is no such requirement that only lawyers or judges can be mediators.
Okay.
Yes, Manya.
Yes.
Let's
So,
go ahead.
my question is, ki like you shared, there are very so much opportunities for the mediator to start up their career as a standing alone in mediation itself. So, how is one mediator can take up his or her career as in a profession, is or in practice itself in mediation?
Well, I'll divide this into two parts. The answer of this in two parts. From the perspective of those who have a legal experience, and when I say legal experience, of course I mean the lawyers, and those who are non-lawyers. For the lawyers, the starting and now both this group, definitely they will there is always one common starting point, and that is networking. That's the end of, I mean, that's the first step you have to do, is networking. You see, even let's say no university, or for that matter no institution, will guarantee you the work. No university would guarantee you what they do, they give you a platform from where you can network, yeah, and get the job. That's exactly what the university is doing. So ultimately, even for mediation as well, you have to, the first and foremost step is to network. Now the question is how and where. Now this is little difficult to answer, in the sense that it all again depends upon where you are, with whom you are associated with, yeah, your locational issues, your geographical presence also is very important and critical in in getting appointment as mediators. Now if I talk from Indian perspective, let's say if you are in Mumbai and Delhi, then there are more chances of you getting that work initially, yeah, rather than if you are in a small city like Pune or somewhere else, you know, tier 2 or tier 3 city, it is difficult. But again, in those cities also, it all depends upon how you network, where, with whom you're sitting. You have to, you see, this is the age of showcase, and that's why social media has become so important part of our life now. So what we are doing in social media, ultimately, we are advertising ourselves at the end of it, yeah. Whatever we are doing, we are simply putting it on social media, and that's exactly, I mean, that is what it has to be done. And networking therefore plays a very important role, because even if you are let's say apart from big or branded institutions like let's say IIM or somewhere, where they will pick you up from that placements part. From the student perspective, I think that also plays an important role, because you have your on-campus placements as well. So there, that is another way of getting into that process, because most of these big law firms, they have a separate dispute resolution vertical within their firm. So no, so according, if you are so much interested into mediation, for that matter, you can definitely project yourself. You can make up your CV, your resume like that you are focused totally on mediation. You should be, participating in the moot events. There are moot competition going across the globe on mediation, which is held by some very prominent institution like ICC and these institutions. You should participate there. Be in touch with the who's who of mediation. There are so many groups, especially on LinkedIn. I think that's a the most important platform for you to be there, to showcase your skill sets about mediation. And of course, from a lawyer's perspective, get yourself registered with, now most of the courts have their court annex mediation centers, especially in big cities like Delhi, Bombay, Bangalore, and all. So get yourself registered with them, and that's how you will be getting those appointments for into mediation. And then, as I said, the social media network. These what I talked about is basically from the court perspective. Then there are private mediation as well. Big time private mediations are happening. So again, it again comes back to your networking, with whom you are networking or socializing. It's very important. So that is the only way as of now to start with. Once this act comes into play, they will be leading down. There will be a council, an all India council, who would be then regulating the process of appointments of mediators. So once that comes to play, then of course there will be proper process and steps which will be known how you can be made up or get an appointment as mediator. But I think this is the only way as of now what you have to do to get appointment as mediator. Yes, Prajwal, you had some question.
So if the time permits, I have a question related to training itself. That if we talk about mediation bill, once it comes into existence, there will be establishment of a body that will be governing mediation in India. So it will be governing all the things related to training and other things. What is your opinion about the eligibility of the mediators? What should be the ideal criteria that should be there for the mediators currently?
See, again, I think it's again is related to what Abbas just asked about whether mediators can only be the lawyers or judges. The criteria again there are two important criteria. One is, of course, the subject matter expertise or knowledge, and secondly, a bare minimum training of the whole process of mediation. That is important. So right now, currently, we have a norm of 40 hours training. So I think that minimum, that much training should be one of the criteria or eligibility of being appointed as mediator. And apart from that, I think what needs to be done is, even you see after training, as I said, it's an art. I mean, not everybody can get trained about it unless that person has that imbibe mentality, imbibe personality to help other people and to be there as mediator. So initially, I would suggest that if you have come out of a 40-hour training, you must then shadow some experienced mediator as an assistant, and try to work with him or her for a couple of matters. Try to understand the whole process, actually how it is happening. Because what you would be doing in training is theory and maybe the role plays, but that's not actual. Things are very different when you are there in the actual cases. So I would suggest that after yourself being trained in, let's say, 40-hour training, you must then shadow some senior or experienced mediator for some time to understand more detailed nuances of the whole process. Yes, Manya.
Yeah, it's very rightly answered, sir. I- So, yeah, can I have my next question, please? Okay, sure. So, sir, as being you are very senior and successful mediator, I would like to know about your journey in mediation.
Well, it started almost, now we are in 22. It started almost 10, 12 years back. Uh, I was actually searching for some different growth avenues for my firm and for my practice, and that's where I came to learn about this Chartered Institute arbitrators. So my journey into mediation actually started with arbitration, and it's very funny that way. So during this, I was fortunate to be made the first part of the first directors of the Chartered Institute Arbitrators India branch in 2011. And then on, the journey started into arbitration. I became qualified as a tutor to train people into international commercial arbitration. Of course, then the opportunity of getting appointments as arbitrators also came along, and the council part also came along. But through this journey of arbitration, I realized that ultimately it's nothing but a sort of mini trial which is happening, especially in our country where we have the retired judges sitting as arbitrators. And so, and therefore, I realized that ultimately it's not leading to the actual or effective solution to the problem, in which, of course, led me to search for, you know, a different avenue, and that's where mediation came into play. And because, of course, with due to my international connections, helped me a lot to follow into mediation as such. And it's again I'm repeating, it's very subjective. I feel so passionate about resolving disputes. So if you are passionate about something, you are bound to be successful. And this exactly is what is required if you want to be successful in mediation. If you come with that passion, because when you are passionate about a particular subject, you will be committed. You would be fully focused on it, and that's the path to success. So, so I was, and I'm still, in fact, very passionate about helping people try to understand their issues and try to work around a solution which would be fair to both the sides. Of course, it's very difficult, and it is not always possible, and and I have faced some very difficult clients and parties who are hell bent on not agreeing to anything and just going on with the fight, and you can't help it. I mean, after one stage you have to accept that fine, it's not going to work. So mediation, as I said, can be unsuccessful, and of course I have also faced such cases. But then it gave me further kind of thoughts to understand why it failed. Give me that inclination or the inspiration to analyze why it failed, what were the reasons. And when you go deep into that, then you may realize even your own mistakes as well. As mediators, I mean, we are humans, so we make mistakes, sitting as counsel, sitting in mediators, arbiters, whatever. So we make mistakes. So when you analyze, you also you also come across your own mistakes. Yeah. So self introspection is very important, and that actually has also helped me a lot being, I won't say successful, but yes, I would say to an extent a satisfied career till this date. Yes, Tanya, you have a question?
Yes, sir. I actually had a question from the other perspective, from a perspective of a mediation advocacy. Right now,
Okay.
if a client comes to an advocate seeking counseling, first solution which is given is of litigation and the statutory reliefs that are available to the client. Mediation or settlement is never the first option for any of the client, and it's even more that the ego that the client comes with, as you said, that ego is rather buttressed. So,
No,
how do
you're,
you see
yeah.
that shift coming? If at all we see that mediation law uh, is near to become in effect in our country. So how and when will that shift come, according to you?
Well, I must appreciate and thank you for asking such an important question, Tanya. It's a very, very pertinent part of our culture. In fact, I was discussing this with in one session with the students of one particular universities, and you see, the problem is that we have we still have a very traditional law school curriculum and culture for that matter. And unfortunately, because of that, we still have that a totally wrong understanding of who a lawyer is. What are the responsibility of a lawyer? We are told in the law school, and it's a common uh, way the people would always point and address that he's a lawyer and he's a person who goes to court, come back in the evening, discuss with the client, again goes back to court and argue for the client. That's the understanding of a lawyer, which is, I would say, just one fraction of the actual responsibility or role of a lawyer. The lawyer has a very, very big role to play for the upliftment and for the empowerment of the society as such. The reason being that today, as you said, a client is coming to you as a lawyer with an expectation, yeah, that whatever problem he or she is facing would be solved by you. You will give a proper advice. You will show that the client the right path for that particular problem. Now, here comes the traditional understanding. We have been taught, so our psychology is that ultimately, I am a lawyer, I have to fight in court. So we never look from the fact of a counselor. We never look from the fact of that this problem can still be resolved without going to the court. Yeah. So unless and until this mindset goes out, there is no end to it. I mean, it's going to happen. We'll be going on and on with litigations. So, and that is the reason why I am now focused on the students, university students, especially the fourth and fifth year students who are just about to come into practice. And my focus and my aim and purpose is to change their mindset towards disputes as a whole, to gain a very holistic approach towards disputes, not adjudicative at all to start with. Every problem, and if you have you are I suppose you are a lawyer or law student, Tanya, correct?
I'm practicing.
Yeah,
I'm practicing.
you're a practicing lawyer. So you see, you would have read the subject jurisprudence.
Yes, sir.
Now, just for those who are not lawyers, probably, but just a common understanding of what that subject is, it's basically, gives the answers to the question of why, who, when, what, where. This is jurisprudence. Yeah.
Yes.
But I'm telling you, 95% of the students in law school does not give serious attention to this subject. Correct, Tanya?
Yes.
Yeah. And, and that is the reason why when they become lawyers, they come with this traditional understanding. With all due respect to all the lawyers and the whosoever there, but I'm just sharing my experience that this is the problem. So our law school curriculum is still that traditional. It still doesn't give the student that holistic mindset of approaching a dispute. So I think that is what is important, that you, and this will not only help you in your career, but it will also help you in your life. Let me tell you that once you are in mediation, if you pursue this as a career, you become a very humble person. Why? Because the very first important part of mediation or the mediator is that you have to be an active listener. So when you see, and this is where the most difficult part, because it's a human nature to react and respond rather than listen. We don't listen, we listen to respond. And that's the problem. But when you are a mediator, you have to be an active listener. You don't have to speak. You have to first listen and then analyze what you have listened and then speak up accordingly or according to your analysis. Now, this is very, very difficult. So therefore, and that's why I said it's a subjective career prospect. It's not cup of tea of everyone, but it's definitely very interesting. So again, coming back to your question, Tanya, that unless and until this mindset change comes into play, I don't think there would be any decrease in litigation for that matter, or the disputes going around.
Just a small follow-up. Like you said that you are focusing on the students. So the professionals like me who have recently joined the profession and are inclined to take their trajectory to mediation or ADA for that matter. What is your advice for them? From a perspective of advocacy right now, because as far as my knowledge goes, my limited knowledge goes, to be empaneled as a mediator or to become as a mediator, there has to be minimum 5 years of experience.
Yeah, that's unfortunate, but well, to start with, yes, it is required, especially in our country. But let me just answer your question about what to do with an example. Let's say there is a matrimonial case coming to you, all right, and the wife is the client who comes to you. Now, this is exact. I'm sharing my own experience of what I do normally in such matrimonial dispute. Now we have a Hindu Marriage Act. Okay,
Yes.
there are straight sections on the
Yes.
grounds for divorce or whatever you have now. The Domestic Violence Act as well, the protection of women rights law guidelines, and so there are so many things now, especially for the women. Now, in spite of that, when let's say a wife is coming to me, approaching me for the issues, what I normally do, I would first listen to her. And let me tell you something that, and this is the Guru Mantra which my mentor told me from on the very first day when I started my practice. He said, never trust your client, because your client is not going to say the truth to you for the very first time. He or she would tell what he or she wants you to listen, what he or she feels right. So never trust your client. And this actually advice has helped me a lot, whether in mediation or even in corporate practice as well. But so what I would do, I would just listen to the client first, maybe 1 or 2 sessions. I just take the notes of what she has told me. And then I would tell her that, will meet up again after some time, maybe a couple of days. And of course, if the situation is not urgent. Now, if there is urgent part, then of course you have to approach for the initial interim release. That's so. I'm just taking an ideal situation. So, so then after she goes out, I'll analyze those notes and try to understand, try to figure out what is the problem, what is the real problem. So after analyzing that note, I would call her again for the next meeting, and there I would start asking questions. Simple questions, nothing, no allegations or nothing else, just simple questions on the notes and my analysis of that notes. So I would just ask her to whether I am correct or not of understanding what she has told me. And through that conversation, things would come out. Yeah.
Yes.
So again, this, so what you are doing, this is again an indirect mediation you are doing at that point of time. But this is not the traditional lawyer's practice. The traditional lawyer would say, okay, fine, this is what you have to say. We'll file a petition and we'll get so and so order and so forth. That's what the first meeting would come out of.
Yes.
But from a mediating advocate, this is what you should be doing. Or from even as a general, I'm saying practice. This is what you should be doing. So once going further now, once I have discussed her part of the case thoroughly, I would normally also ask her to call her husband and try to listen to his side as well. Now, this is the difficult part, because if they are in such a dispute or if they are at such a stage, of course, the other side would never come. Yeah. But I would try to directly, speak with him, of course, in her presence. Many times this may, worsen the situation. So you have to be careful about this particular stage. All right. Then let's say I am successful in this, the husband comes, but I will not meet him alone. I would also ask the wife to be there, but maybe sitting out of my cabin. Yeah, initially. And then again, the same process with the husband. He may open up, he may not open up, depending upon the facts of the case. But at least you know the second part of it, the other part of it. Yeah. And then I call both of them together, and there would be series of sittings. Many times the situation will go on, to a very extremes. So you have to be careful, but this all helps. You see what happens, especially, and why I'm taking this matrimonial dispute, because this is where mediation is the most effective solution.
Yes.
Because and especially in our culture, and again it goes back to the communication thing which I have mentioned in the very beginning. Because the situation, cultural, social in our countries like this, that the relations, there is so much decrease of communication between the parties. And thanks to social media, I would say that, and of course, COVID actually, we came with this thing that maintain social distance. Now, this has been taken literally by the people, and even if you see a family of 4 in a restaurant, all of them are down with their cell phones, sitting together maybe on the one table, but all of them are having their own cell phone. They're busy in that. This is what relations have come down to. And so therefore what happens is that either they are not able to communicate, and that is where they want to, and this all bursts out in these meetings, in these situations. So you have to be careful how you handle those situations, but it helps. At the end of it, the person, would feel relieved that, okay, I have said what I wanted to say for such a long time. Maybe he or she didn't have the courage to say straight to that the spouse, but at least in front of someone. So but these all are very important for you. So as a lawyer, you can then reanalyze that what is the crux of the matter. This is so, and then you have to develop on that case, of course, taking total understanding of the fact that you have to protect the interest of the client as well, but not at the cost of the husband. So if you start doing this as a lawyer, I have just given you one example of matrimonial because that is easy to understand. But if you start adopting this kind of approach as a lawyer, even with your corporate clients, I'm sure things would be very different and positive. So start adopting this holistic approach towards, advising your clients. Manya, I think we have exceeded time, yeah?
It's totally upon your convenience. I don't have any problem.
Well, as I said, it's my passion, so I have no problems.
No worries, no worries.
So
So yeah,
I got my answer, sir. Thank you so much.
Pleasure. Yeah. Yes, ma'am.
yeah, yes. I request anyone, if you have any questions, then you may ask right now here itself. I think we can take one more question if possible. And otherwise, if you have any questions, we can go for our LinkedIn page and you can type us. We can give the best answers and with the help of sir. And you can write us on our mail IDs also. And I request everyone to please fill the feedback form also, which is already shared in the chat box, and please let us know how you feel about this platform and what you think about the particular webinar series. And if you have any doubt related to anything, do write us on our LinkedIn page, any social media, or on our email IDs. So yes, so sir, we have one question. I think we can take one more.
Yeah. Go ahead.
Okay, sure. So there is a one question, or Mr. Here it is. So there is a question of Mr. Sumesh, that there are a lot of dispute in consumer related matters with mediation bill. Do you see a major spurt?
I'm sorry. There is a major spurge in the consumer matter.
Yeah, he's saying there is a lot of dispute in consumer related matters with mediation bill. Do you see a major spurt?
Sir, I just wanted to know, sir, now with this mediation coming up, will there be an increase in consumer related matters in mediation? It will come to mediation. This is not in present case now.
If I understand this question in this correctly, that you see, in consumer, there is already a amendment which has come into the Consumer Protection Act, which now prescribes mediation as a sort of mandate for the Consumer Commission to employ for consumer dispute resolution. So, and of course, it of course has the support from both the judiciary as well as legislations. And now we are seeing, the experts are being appointed as mediators under respective state consumer commissions, and the matters are being referred to them for resolving the dispute of consumers especially. So that's my take on it, but I hope I have understood your question correctly. Is this what you were asked, or?
I was only because since earlier, even a routine matter, just for an example, I buy a car from somewhere, a 20 lakh car, and there is an issue. In normal cases, either you yourself go to the dealer and mediate yourself to get a deal out of it, or you go to the consumer court. Now with this thing coming officially in the mediation, domain, do you think that this consumer court business will, die down and it will all shift to mediation because it's an easier way out, particularly for consumer related matters, because people are more keen for resolution in such matters at an easier way and may prefer mediation as a way out.
Yeah, so that's what I'm saying. So that exactly is what has been now been put into the act itself. So it will be definitely benefiting the consumers. No doubt about that. Because even you see, even the consumer matters are taking so many long years to get finally resolved. And again, it has 3 tiers of a district and a state and a national, and again then to Supreme Court. Sorry, 4 tiers for that. So mediation, I think, is the best way out to cut the whole 4 tiers and so many years of litigation into maybe, let's say, 2-3 sittings.
Yes.
Hardly, because again, in majority of the consumer disputes, the corporates also know where they have gone wrong. Of course, there are technical aspect to it as well, depending upon the cases. But again, the parties knows where they are wrong and where they are right. So if they know this, why they are litigating? The best way to mediate, come to an understanding and resolve the matter.
Thank you, sir. Thank you.
Therefore, mediation definitely is going to give a much required boost to consumer dispute resolution.
Yes, that is what I wanted to ask. Thank you, sir.
Okay. Yeah, thank you so much, sir, for this wonderful, insightful journey, for this amazing topic, mediation as a profession. I think everyone doubt has been cleared. And if anyone doubt has been left, I'm very sorry because we have such a wonderful time as sir has been also go for such amazing journey. So,
I think
yes.
there was one person who was asking about ODR
Yeah.
on the chat.
Yeah, let me question it, sir. Sir,
I think we have already discussed about ODR. I suppose
yes.
When Prajwal has already asked that question.
Yes. Prajwal has already asked about the ODR thing in the way of mediation itself.
Maybe that participant would not be there at that time. It might be the case.
No, maybe itself. Yeah, maybe, or he may have some problem of network. Yeah, sir. It's a question from Saksham Tiwari.
Yeah.
Yes.
I read. Anyway, thank you so much, Manya and Karuna Mediation, for giving me this opportunity to interact and share my thoughts. And I look forward to sharing more such thoughts.
Yeah, sure, sir.
And you can share my emails with them if they want to be in touch with me. You can share my email. You can connect me with on LinkedIn as well.
Yeah.
And would be happy to discuss it further.
Sure, sir. Yes, we are too, sir. I request everyone to please fill the feedback form. And yeah, thank you for such a wonderful, amazing session and interactive one, especially. And thank you, sir. I would like to know your thoughts about Karuna mediation.
Well, what attracted me to say yes is your company's name, which is Karuna, which of course relates to empathy.
Yes.
Though actually it means sympathy, but sympathy is part of empathy as such. So unless until you are not able to sympathize with someone, you cannot empathize with that person. So definitely your name is very appropriate. When I'm saying your name is the institution name is very appropriate for promoting mediation. And I think you are doing a wonderful work. So keep doing it, and happy to support and help you for that.
Thank you so much, sir. And we also thanks Mr. Sahil Kapoor for providing this wonderful platform of Karuna Mediation, for having such wonderful sessions with us, all of us.
Thank
Yeah,
you.
thank you,
Okay.
everyone.
Have
Thank you,
a
sir.
nice weekend, all of you. Thank you so much.
Yeah, thank you, sir. You too, sir. Have a nice day, everyone. Yeah, thank you.